Welcome to the Deep Dive. We're the place you come to. Really get under the hood of those big legal decisions, minus all the dense jargon.
Yeah, we try to cut through it.
Today, we're definitely cutting through something dense. It's a pretty significant Supreme Court case from June 2025, Esteras v. United States.
That's right. And this deep dive, it's basically your shortcut to figuring out what this ruling means.
Yeah.
It fundamentally changes how federal judges have to think about punishment when someone violates supervised release.
Supervised release, that period after prison.
Exactly. And if you've ever sort of wondered about the line between punishment and, say, rehabilitation in the justice system, well, this case shows a really sharp line. It's quite fascinating.
It sounds critical, yeah. Especially since, supervised release is a massive part of the federal system. So to really get why this matters, let's talk about the actual person involved, Edgardo Esteras. What happened with him?
Okay, so Esteras, he was convicted years back for a heroin conspiracy, served his time, did the prison sentence, then he gets out on supervised release.
Which is like conditional freedom, right? You have rules to follow.
Exactly. Conditional liberty. The whole idea is monitoring, giving some structure, maybe some help, getting back into, regular life. Post-confinement assistance, they call it.
Okay, so far so good. But obviously something went wrong.
It did. About 3 years into his release period, he gets arrested again. This time on charges related to domestic violence, involved threats, apparently firing a gun into a vehicle. Serious stuff.
Definitely a violation of his release condition. So the court steps in.
Right. The district court moved to revoke his supervised release, pulled him back in.
And sent him back to prison. For how long?
They imposed a 24-month sentence. Now, the 24 months itself wasn't really the legal fight. It was the reason the judge gave.
Ah, the justification. What did the judge say?
Well, the judge specifically noted that Esteras' original sentence, the one for the drug conspiracy years ago, had been, quote, rather lenient.
Lenient? Wow.
Yeah. And because of that perceived leniency, the judge said this new, longer revocation sentence was needed partly to promote respect for the law.
Hold on. So the judge was kind of like making up for the original sentence being supposedly too soft years later at the revocation stage.
That's exactly how it looked. And that reasoning, using the revocation hearing to basically add punishment for the original crime or to promote respect for that law, that's what got the Supreme Court's attention.
Oh, yeah.
It really teed up this fundamental question. When someone violates supervised release, is the judge allowed to look backward and punish the past crime, or do they have to focus only on the future, managing risk going forward?
Right. Okay, this definitely sounds like we need to get into the weeds of the law here.
Okay.
Because you mentioned it all hinges on how Congress wrote the rules. These lists of factors judges have to consider.
That's the absolute core of it. You have to understand there are two different sets of rules, basically. First, when a court imposes the initial sentence, prison, probation, whatever, there's a law, 18 U.S.C. section 3553A, that lists 10 specific factors they must consider. It's mandatory.
10 factors. And these cover the big reasons we have punishment in the first place, right? The classic philosophical justifications.
Precisely. You've got the 4 main purposes baked into those 10 factors. It's worth quickly naming them because it matters which ones apply later.
Let's hear them.
So number 1, and this is crucial, retribution. That's in section 3553A, 2A. It's about just punishment, the seriousness of the crime you actually committed, and importantly, promoting respect for the law. This is the one looking backward.
Got it. Backward-looking retribution. What else?
The other 3 are all fundamentally forward-looking. You have deterrence, trying to stop this person or others from committing crimes in the future.
Makes sense.
Then incapacitation, basically, protecting the public by keeping the person locked up or restricted.
Right.
And finally, rehabilitation, trying to help the person become a law-abiding citizen.
Okay. Retribution, deterrence, incapacitation, rehabilitation. 4 big pillars. And for the initial sentence, the judge weighs all of these using those 10 factors.
Correct. Including retribution for the seriousness of the crime itself. That makes sense for the initial punishment phase.
But supervised release is different. You said it's not technically part of the punishment for the crime?
Exactly. The court emphasizes this. It's a period of conditional liberty that starts after the punishment part is over. It's supposed to be about monitoring and helping people transition. Different purpose.
So when Congress wrote the specific rules for supervised release in a different section, section 35A3, what did they do with that list of 10 factors?
This is where it gets really interesting, and frankly, it's the key to the whole ruling. When Congress wrote the law for imposing supervised release, and critically, for revoking it if someone violates the rules, it pointed back to that main list of factors in Section 3553A.
Okay.
But it was very selective. It explicitly listed only 8 of the original 10 factors for the judge to consider in the supervised release context.
8 out of 10? That doesn't sound like an accident. Congress was specific. So what got left out? What are the missing 2?
Well, one is kind of a technicality about sentence types that doesn't really fit revocation, but the big one, the one this whole Esteras case turns on, is 3553A2.
Wait, that's the retribution one?
Bingo. The factor covering just punishment, seriousness of the original offense, and promoting respect for the law based on that original offense. That's the one Congress did not include in the list for supervised release decisions.
So Congress basically took the legal justification for punishing someone again for the seriousness of their original crime right off the table for supervised release violations.
That is precisely the interpretation the Supreme Court adopted. It's a deliberate omission.
Okay, so the court sees this omission. How do they use that to say what the judge did in Esteras' case was wrong?
They pulled out a classic tool of statutory interpretation. It's one of those Latin phrases lawyers like.
Uh-oh, lay it on us.
Expressio unius est exclusio ulterius.
Okay, English, please.
Right. It basically means the expression of one thing implies the exclusion of others.
Okay. Like if I give my kid a very specific grocery list with 8 things on it,
Yeah.
the reasonable assumption is that the 2 things I deliberately didn't put on the list, like say ice cream and candy, shouldn't end up in the cart.
That's a perfect analogy. Since Congress carefully listed 8 factors from C3553A to be considered for revocation, the court said the logical conclusion is that the 2 factors left off the list, especially the retribution factor for the original crime, were intentionally excluded. Judges aren't supposed to consider them.
So this isn't just about checking boxes off a list. The court is making a bigger point about what supervised release is even for, philosophically.
Absolutely. Majority opinion really hammered this home. They stated supervised release is not a punishment in lieu of incarceration. It's there to fulfill rehabilitative ends and provide individuals with post-confinement assistance. The goal is managing future risk and helping people succeed after prison, not repunishing them for what they already served time for.
That forward-looking versus backward-looking distinction seems absolutely crucial here.
It's everything. So when a violation happens, doesn't matter if it's technical, like failing a drug test or a new crime. Like in Esteras' case, the judge's focus must be on those forward-looking goals: deterrence, incapacitation, rehabilitation, using the factors Congress did list.
But they absolutely cannot use the revocation to impose more punishment just because they think the original crime was really bad or the first sentence was too short. That backward-looking retribution is off limits.
Correct. The punishment for the original crime is done. The revocation sentence has to be justified based on future concerns, not past grievances.
Okay, but here's where I imagine it gets tricky for the judges on the ground. The government and the justices who dissented in this case, they argued this is almost impossible to do in practice. They called it a mind-bending exercise.
And you can see why they'd say that. It is a real practical challenge. The dissenters pointed out, look, judges are still required to consider factor number 1 from the big list, the nature and circumstances of the offense, meaning the original crime. That factor is on the list of 8 allowed things.
Right.
So how, they asked, can a judge realistically consider the nature and circumstances of, say, a really violent original crime without also thinking about its seriousness or the need to promote respect for the law? Those seem like the forbidden retributive ideas, but they feel naturally connected to the facts of the crime itself.
Yeah, it feels like trying to think about fire without thinking about heat.
Yeah.
How did the majority say judges are supposed to separate those thoughts?
They essentially created what you could call a purpose filter. The court said, yes, judges must look at the nature and circumstances of that original offense. But crucially, they can only use that information to inform the allowed forward-looking factors.
Okay, unpack that. How does the filter work? Give us an example.
All right, let's say the original crime was a very sophisticated, large-scale financial fraud. Years later, the person violates supervised release. Maybe they associate with known criminals, violating a condition.
Right.
The judge can look back at the details of that complex fraud, but only for specific forward-looking reasons. For instance, the judge might say, the sophisticated nature of this original fraud tells me this person has skills and tendencies that pose a significant future risk to the public if they reconnect with criminal elements. That informs incapacitation, the need to protect the public.
So the allowed thought process is, the nature of the past crime indicates a future risk, therefore a longer revocation sentence is needed for public safety or deterrence.
Exactly. That's using the past facts to justify a forward-looking purpose. What the judge cannot do is say, wow, that original fraud was just terrible. Society needs to see consequences for that level of disrespect for the law, and maybe the first sentence wasn't enough, so I'm adding time now for that reason.
That's the forbidden thought. Using the revocation to add punishment for the original crime's seriousness or to promote respect for the law in a retributive sense.
Correct. That's the filter. Use the facts, but only channel them towards deterrence, incapacitation, or rehabilitation needs, not backward-looking retribution for the old crime.
That is asking a lot of judges. It requires real mental discipline and, I guess, careful wording in their decisions.
It really does. One justice even called it a soul-searching obligation for judges. And the court understood this was tough, which is why they also talked about how appeals courts should handle it.
Right. What happens if a judge slips up or seems to slip up and mentions something that sounds like retribution for the original crime? Is the sentence automatically overturned on appeal?
Not automatically. The court set up a procedure. If the defendant's lawyer objects right then and there during the hearing, saying, Your Honor, that sounds like you're considering the forbidden factor, then the judge gets a chance to clarify. The judge can explain, no, I mentioned the seriousness of the prior offense only because it informs my assessment of the defendant's risk of reoffending, tying it back to incapacitation or deterrence.
So a chance to correct the record and show they used the purpose filter correctly?
Exactly. But, and this is a big but, if the lawyer doesn't object at that moment, which, can easily happen in busy courtrooms, then it's much harder to win on appeal. It gets reviewed under a standard called plain error. That means the mistake has to be incredibly obvious, really clear from the record, that the judge definitely relied on the forbidden retributive reason. It's a high bar.
Got it. So let's bring this all together for someone listening. For you trying to make sense of this, what's the big takeaway from Esteras? Why does this matter outside the courtroom?
I think the biggest thing is that the Supreme Court has put a formal limit on what judges can do in these revocation hearings. It clarifies that supervised release isn't supposed to be punishment part 2. It's meant to be about managing the transition back to society and ensuring public safety going forward. So if someone on supervised release messes up, the judge's job isn't to punish them again for the crime they already served time for, especially not because the judge felt the original sentence was maybe too light. The focus has to be entirely on the future. Future risk, future compliance, future rehabilitation.
That feels like a really important statement about how our system views justice after incarceration. Once the sentence is served, that part is theoretically done.
That's the principle, yes. The punishment phase for that specific crime is complete. Now the system shifts focus.
Okay, but reading through the source material, it felt like there was maybe one more layer, a lingering question the court didn't fully resolve. Something about retribution itself.
You picked up on that, yes. The main opinion clearly says retribution for the original crime is out. But two justices, Sotomayor and Jackson, wrote a concurring opinion. They agreed with the result, but they wanted to go further.
Further how?
They argued that maybe all retribution should be off the table during supervised release revocation. Not just retribution for the original crime, but even retribution for the act of violating the release conditions itself.
Whoa. Oh, explain that. So if someone violates release by, say, repeatedly failing drug tests, the majority says you can't revoke them to add punishment for their original drug crime. But Sotomayor and Jackson were suggesting maybe you can't even punish them just for the failure to follow the rules, that any sentence has to be purely about deterring future drug use or getting them into treatment, not just punishment for the rule breaking itself.
That's exactly the unresolved tension they highlighted. Can revocation ever have any punitive element, even if it's directed only at the violation behavior? Or must it be 100% forward-looking, focused solely on managing risk and promoting compliance through non-punitive means? The current ruling settled the big question about the original crime, but that deeper philosophical debate about whether supervised release can ever be punitive, even for the violation itself, that's still lingering.
That is definitely something to chew on. A really interesting nuance left for the future.
It is. It shows how these legal lines are constantly being drawn and redrawn.
Well, thank you. That was a fantastic job of making a really complex decision full of Latin phrases and statutory lists feel much clearer.
Happy to do it. It's an important one.
Absolutely. And thank you, our listener, for joining us on the Deep Dive. We'll catch you next time.